HKIAC, and KCAB. I'll move on to Francis. Francis Xavier, Senior Counsel, is the Regional Head, Dispute Resolution Group of Raja and Tan. Francis was appointed Senior Counsel in January 2009 and practices international commercial and treaty arbitration and litigation. He's actively involved in cross-border commercial disputes in the area of corporate banking, property, financial, and investment-related claims. He has appeared as counsel and has acted as arbitrator, both party appointed and presiding, in a large number of arbitrations, both ad hoc and administered arbitrations, including by ICSID, ICC, SIAC, AIAC, HKIAC, BANI, and the Permanent Court of Arbitration. He is the past global president of the Chartered Institute of Arbitrators UK, and also the past president of the Inter-Pacific Bar Association. He's a chartered arbitrator and also a past chairman of the Singapore branch of the Chartered Institute of Arbitrators. Next up, Sanjay Mohan. Sanjay was called to the Malaysian Bar in 1995. His primary practice areas are in construction and energy-related disputes. With a career spanning 30 years, he has been involved in more than 100 arbitrations and court-related matters dealing primarily in construction and energy-related disputes. Sanjay has been recognized in Chambers and Partners and various other ranking publications as one of the leading construction lawyers in Malaysia. Apart from his construction law practice, Sanjay has also significant and wide-ranging experience in commercial and civil disputes. He is particularly interested in the technical areas arising from construction and energy-related disputes. In recent times, he has been specifically engaged to cross-examine expert witnesses in court and in arbitration. He has also been involved in several landmark decisions in relation to construction and energy-related disputes. So this is a very short snapshot of your speakers today. It took quite a bit of effort to chop all that down given their respective CVs. With that, I'll get into the topic of the day, interlocutory applications in arbitration. Now, we are not talking about only interlocutory applications in arbitration. We are also going to deal with interlocutory applications in court to facilitate the arbitration process. So this afternoon, what we will hear from your speakers are challenges to jurisdictional issues or the challenges to the jurisdiction of the tribunal, applications to join a party and for consolidation of arbitration hearings or proceedings, a stay, whether it's a stay of the arbitral proceedings or stay of court proceedings to facilitate the arbitration, discovery applications, and interim measures. More importantly, we will be spending some time listening to war stories from your speakers here, because what the rules provide for, you can read for yourselves. But what we will endeavor to provide to our audience today is really the experience of our speakers as to how these interlocutory applications are to be dealt with in practical situations. Right. So with that, I will start with the jurisdictional issue, challenges to a tribunal's jurisdiction. I'm going to ask Raj first, if I can. Could you let us know, Raj, in your experience or from what you see in the rules, when are challenges to jurisdiction normally taken?
Well, I think the rules, the BICAM rules in particular, seem to be quite explicit. You're supposed to take the jurisdictional objection in the pleading stage, the statement of defense, at the very latest. I think there's a 15-day long stop from the time that you get to know about the jurisdictional deficiency. So that is a kind of thing that then you have the more difficult question is where do you bring the challenge? Generally speaking, the tribunals have power to rule in their own jurisdiction. So you would, your first port of call would be run the jurisdictional challenge before your tribunal. And then if the tribunal declines to allow the jurisdictional challenge, then you have a provision under the Act, which is Section 18 of the Act. That's the Arbitration Act, and you can go to court. You have a one-shot challenge in court, because if you fail in court, there's no further appeal. So that can be done at the point of time that you take the challenge. The other way to do it is for the tribunal to defer that jurisdictional question until the award is made, in which case you then have your provisions under the Arbitration Act to set aside the award or refuse enforcement of the award if the award was made without jurisdiction or it was made beyond the arbitrator's jurisdiction. So in a nutshell, you can take the jurisdictional challenge immediately, or you can wait for it and take it at the end. Obviously, if it's a jurisdictional challenge, it may be the party who is taking the challenge would be well advised to take it early, because otherwise you don't waste your time and money going to a full-blown arbitration if in fact you succeed. That's my take on it for the time being. Perhaps you can maybe ask the others what they may have to say about this.
Thanks, Raj. I was going to ask you, sitting as arbitrator, what would your preference be? But I think you've answered that, to deal with it upfront as a preliminary issue rather than to take it to leave it to the final award.
Yes.
So the Rule 17 of the BICM rules that you mentioned, Raj, provides for that as well. You can either take it as a preliminary issue or right at the end as part of the final award determination. That's quite consistent, I think, with Section 18 of our Arbitration Act as well. So I'll cross over to Francis. Can I start by asking you, Francis, sitting as arbitrator, what would your preference be? Would you take it as an issue?
Right. I just wanted to make 2 points, Joon Liang. The first answers your question, and that is, this is a vexed question, right? And although of course, the common sense answer is to Summit needs to mute her microphone. Never mind. You see, the modern tendency is, of course, to have it heard before to save costs. All right. But you know, in very complex cases, it's not so easy to decide. The main question is this: what is the degree of overlap between the issues, fact or law relating to the jurisdiction versus the merits? And in many of the cases I've said you find there is a huge degree of overlap. So then the tendency is for the tribunal to order it to be heard all at one go, rather than have all the witnesses come out one time for the jurisdiction and then come back another time for the merits if the jurisdiction is overruled. But you know, Raj is obviously right. I mean, if it is a freestanding issue, especially if it's a freestanding issue, you dispose of it early, even if there's some overlap, so long as the overlap is not significant, right? The second point I want to make is that, you know, the situation in Malaysia under the model law for jurisdiction challenges varies with other countries like Singapore. So under the Malaysian legislation, if the tribunal makes a positive jurisdictional ruling, that means there is a challenge to the tribunal's jurisdiction and the tribunal rules there is jurisdiction. This is called a positive jurisdictional ruling. You can then appeal that if you're not happy. But if the tribunal makes a contrary ruling, which is that it agrees that it has no jurisdiction, that is known as a negative jurisdictional ruling. Under the model law and Malaysian law provisions, as I understand it, being as practicing in Singapore, so I'll have to be guided by all of you, is negative jurisdictional ruling cannot be appealed against in Malaysia. Whereas in Singapore, it is different. In Singapore, we specifically amended our Arbitration Act to specify that both positive and negative jurisdictional rulings can be appealed against, because it is the same rationale. If the tribunal makes a mistake and says, I have no jurisdiction, why should you be stuck with that, So I just wanted to point that out. Back to you, Joon Liang.
Thanks, Francis. Actually, that raises a good point. Likewise, if the High Court makes a negative jurisdictional ruling on an appeal from the tribunal, there's only one round of appeal under our Act, Section 1810, I think it is, and the High Court's decision is final, then that's the end of the jurisdictional issue. There is no appeal. That, from recollection, seems to be consonant with the model law approach. But that gives rise to a problem, because really that is the end of the road for the claimant. Whereas if the arbitrator leaves the issue of jurisdiction to the end to be dealt with in the final award, there are the setting aside provisions on jurisdictional issues, and that is appealable. So with that, can I turn over to you, Sanjay? As the arbitrator, how would you deal with it?
I would like to deal with it upfront. I think I take Francis's point that if there's a lot of overlap between the factual issues and there's a need to call the witnesses again, it's probably better to treat it all in one go. But in terms of saving time and costs, it makes sense to try to do it if you can upfront and deal with it separately. Having said that, Fu, I just want to raise 2 points, which is this. I recently had a case where there was a jurisdictional challenge taken, and the arbitrator found, I was acting for the claimant, the arbitrator found that there was jurisdiction. It was on an issue of law in relation to a company in liquidation on the sanction given by the official liquidator. And on appeal, the respondent appealed, and the High Court found that the arbitrator was wrong on a question of law. So what we have here is a situation where the learned judge in the High Court took a contrary view on the law with that of the arbitrator. But because the mechanism is an appeal mechanism, it allowed for the judge to take the view that it's a rehearing, and therefore the judge could look into whether give their interpretation of the law. So that it was a very unfortunate result for my client, and is I think it's the fact that we cannot appeal further from the High Court is something that needs to be looked at. The other point I wish to make is this. Whilst we may have very good lawyers who sit as arbitrators, frequently we encounter architects and QSs and engineers who are not legally trained who sit as arbitrators. So jurisdictional arguments sometimes, when they are fine legal points, is a difficult thing for them to grapple with. So I think from a practical standpoint, if you think that you may be faced with a jurisdictional challenge and on a nuanced legal argument, it may make sense to ensure your arbitrator who is somebody who understands and appreciates these issues.
Joon Liang, if you don't mind, there is a war story that I think might be relevant at this point, and this relates to the question of waiver. Because the thing is, in a case that was actually reported called the Daewoo case, there were 6 different work orders, 2 of which had arbitration clauses and the rest did not. But the claimant brought an arbitration in respect of all 6, and we took an objection, jurisdictional objection. And this jurisdictional objection, we did not succeed before the arbitrator, so we took it to court. And at the court of first instance agreed with us, but the Court of Appeal actually reversed it. This is the case of Bauer and Daewoo, because they said that in the course of the proceedings, the parties had actually tried to settle it, and there was an application for an amendment to say that the matter was settled, and that was enough to constitute a waiver. At that point in time, Justice Gopal Sriram did not accept my argument that any change ought to be in writing, because it was a requirement of the Arbitration Act. But later on, the federal court in another case, I can't remember the name off the top of my head, actually took that point where Darren Boone argued and succeeded in showing that you could not infer or you could not constitute jurisdiction by conduct. It had to be something in writing.
Thank you for that, Raj. Actually, that takes us nicely to the next topic. Your 6 work orders, some of which did not have arbitration agreements. That takes us to the issue of consolidation and joinder of parties. I will turn to Sanjay. Sanjay, could you perhaps start by telling us more about the BICM rules? What are the provisions that we should look at for the purposes of joinder of parties and consolidation?
So for joinder of, let me deal with consolidation first. For consolidation, you have Rule 8 and the BICM rules, which essentially allows parties, if they so choose for proceedings to be consolidated and and to be heard. I think there are various rules that need to be met before the tribunal will grant permission for the consolidation of proceedings. And that's similar to our Section 40 of the Arbitration Act. In terms of joinder, that's in Rule 7, and that's quite interesting because it says here that upon the application of a party, non-party, provided there exist exceptional circumstances, the tribunal may join one or more additional parties to a pending arbitration. But he goes on to say that if that additional party is prima facie bound by the arbitration agreement, I don't know whether there's any case law which actually explains what Rule 7.1a means as to how additional party can be prima facie be bound by that arbitration agreement. It seems quite an interesting position to take, given that arbitration agreements are between a contracting party. I'll be interested to see how that works. I haven't seen that myself. I'm not sure whether Francis or Raj or has seen a situation which would fit into Rule 7.1a.
I suppose, Sanjay, that brings up the issue of the group of companies principle that you spoke about yesterday when we were having this discussion.
Yeah, I think that's slightly different because I think that there's an Indian case, I think 2022 case, where the court found that the arbitration agreement extends and they are bound by the award. So it's slightly different in the sense that here a party wants to join the arbitration as opposed to being bound by the award.
Yes. Right. So on the issue of, before I come back further to this issue of the group of companies, Sanjay, let's turn to Raj in terms of a joinder of parties and consolidation. Any war stories from your side?
Not something live, because I think mostly it's been done by consent. I don't think I've had a situation where there's been a challenge or something, but I think there's been one situation which came up before me when I was actually reviewing draft awards in the ICC. I cannot divulge the particulars, but in that particular case, there was an application for a joinder, and I think it was not so much, I think it was more to do with this separate legal entity issue, because there would have been a company that owned, that set up another company in Indonesia in order to, to build a power station or something. And what happened was the arbitration agreement was between the Indonesian entity, and obviously they were trying to bring in the parent company as a party. And I think in that particular instance, I think there were the application failed.
All right. Can I turn over to you, Francis?
Julia, I haven't really had any particular situation on the point that Sanjay was talking about a while ago, which is prima facie bound. But I think I recall, and I'm getting Juhi, my trainee, to check now. I think there was one case which I recall where the fact situation was such that a third party, by way of I think it was a construction dispute, and the third party who was very closely associated with that contract between the contracting parties, and all parties had behaved in such a way as if that party was also bound by a number of the covenants, and could some of the benefits of those covenants would also go to him. And in those circumstances, the court had found that he was prima facie bound, right? So I guess as Sanjay says, it's a question of fact, it's quite rare, but if the facts scream, and satisfy that test, then you can,
So
and facts are always malleable.
Yeah, so I suppose it would be in situations where the claimant, for example, is in there's an arbitration agreement with company A, but the reality is that the obligations are substantially to be performed by a related company, company B, and remedies are sought against company B. Then in that instance, although the arbitration agreement is signed between company A and the claimant, there would be grounds under 7.1, provided the facts bear it out, to bring in Company B as a party to the arbitration. Of course, as Sanjay says, the principle of the group of companies, so I think it's called the Dow Chemicals principle, is used largely to attach companies that are not non-parties to an arbitration award, to tie them into the outcome of an arbitration award on the basis that these are companies related to a party within the arbitration. I think that there seems to be some Indian jurisprudence on this. Plural Controls and Charon Properties, I think, is one of them. And
Indians and the French, only the Indians and the French have considered this. There doesn't appear to be any English or Australian cases which seem to have adopted a similar jurisprudential approach.
Yes.
Sorry.
Right.
Yeah, sorry. Now that you mentioned the French one, I was thinking of the Dalla Estates, the very famous Dalla Estates case. I think the government of Pakistan had set up a special purpose company to do some development work somewhere. I think it was in the Middle East or something. And then the company, they wound up the company, but the arbitration was brought against the government of Pakistan, and according to the French, it was an ICC tribunal. And they found that the Pakistani company the government was liable. It went all the way up to the French Court of Appeal, and they also tried to enforce in England. And interestingly enough, the English courts came to a different conclusion from the French Court de Cassation, which is the top court in Paris. So in this sort of situation, when we are talking about who is really the person or the entity who is in substance in control of that becomes very much an issue, and has different outcomes under say civil law jurisdictions like France or common law jurisdictions like England.
Thank you for that, Raj. With that, I will move over to the next subtopic that we have, stay proceedings. I'm going to pose this question to you, Sanjay. But related to the issue of having multiple parties, some of whom are parties to the arbitration agreement, some of whom are not. Typically, we have a situation where either court proceedings are commenced first. Between some of the parties, there is an arbitration agreement, and so there's a stay application for limited parties within that court litigation process. The reverse could also be possible. The arbitration commences between the arbitration parties first, then related court proceedings are commenced to bring in wider parties because they are not party to the arbitration agreement. There could also be a situation where criminal proceedings are on foot. And I think there are some recent decisions in Malaysia where criminal prosecution is on foot, and there are related civil proceedings and arbitration. So a number of permutations, Sanjay. The question that I have for you, what are the situations you have come across and what are the options in terms of seeking a stay?
Right. So, well, I've been really on the plaintiff in the case, the 2 or 3 cases where I filed the suit against the party which is entered into the arbitration agreement and various other individuals, directors, shareholders, typically using the Companies Act argument, Section 540 of the Companies Act to hold the directors liable as well. Now, in fact, I had Raj as my opponent counsel on one of these matters where Raj applied for a stay vis-a-vis the arbitration agreement, which is a PAM form contract, and the High Court judge allowed that stay subject to the arbitration being concluded within 9 months. When that arbitration wasn't concluded within 9 months, I then went back to court and I said, look, Raj was unfortunately no longer the counsel at that point in time. Somebody else took over and was trying to pay them. Just want to make that clear. So then I went and got the stay lifted and varied, and we went on to court and we finished the trial. But you see, it really depends on how the judge wants to look at the matters. I mean, you've got Tomalugan, you've got Protesco, which deals with all these issues, right? And it's pretty much left to the discretion of the judge as to how he or she wants to deal with it, what they want to hear first, what they don't want to hear first. And I think both Tomalugan and Protesco set out the guidelines which need to be followed. And I think essentially as whichever argument you want to take, one has to be practical about it as well, and see how you want to deal with it. But sitting as arbitrator, I think it's far more difficult, because if proceedings are commenced in court while you're sitting as arbitrator, and there are overlapping issues, what do? Do you then stay the arbitration? Do you then proceed with the arbitration, and you wait for the High Court to complete, or do you just wait for the High Court to complete? What about the Court of Appeal and the Federal Court? Do you wait for all that to be done? So my view is, unless the court tells me to stop, I'm going to go ahead. Let them go and take whatever order they want. So, I'll be bound by the order, but at least I'm bound by a court order, which I can't do anything about it. So that's my preferred approach. The one time I had to encounter this problem. Thank
you, Sanjay. So cases like Tomolugan, I suppose it's on the arbitrability of the subject matter. It becomes less difficult, because if it's not arbitrable, it's not arbitrable. You've got to look at the alternative option of going to court. But in the situation where the dispute is arbitrable and it's prima facie governed by the arbitration agreement, but yet you have other parties involved and parallel proceedings, then it's because ultimately Section 10 is discretionary. Let me turn to you, Raj. Since
sorry, before Raj steps in, there is a federal court case, I think it's Juaheir, where the federal court seems to take the test seems to be justice of the case sort of test, Yeah, so I think that allows the judge a bit more discretion than the narrow interpretation of Section 10.
Yes.
Sorry, Raj, I interrupted you.
Yeah, sorry.
I was going to turn to you, Raj, because Sanjay mentioned that he was opponent on that matter.
Yeah. Well, if you don't mind, I think that one I can't remember too much about it, but there have been a couple since. One of them where we were actually arguing we were trying to promote the Tomologan approach. Tomologan was a decision of the Court of Appeal in Singapore, Sundaresh Menon decision, which is very, very well written. All the factors were there, but then we had Protasco in the Court of Appeal, where Justice Nalini appeared to accept the principles, but then basically fudged the issue by saying, as a matter of fact, she didn't want to grant the stay. I mean, the issue was really, you had a stay which was dependent on a finding that would have been made in the arbitration between the parties to an arbitration agreement. So in Tomologan, I think they did the right thing by saying they exercised the discretionary case management powers of the court to say that, look, we're not saying that you've got an absolute stay, but what we're saying is that you go off and you decide this question of fact in the arbitration, then the courts will pick up that question of fact, and run with it after that, which I think is a sensible outcome, right? The second one, which if you don't mind, I want to quickly push in, it's actually nothing to do with this kind of stay, but it was something that came up before me sitting as arbitrator. Because there was an application before me for an injunction to preserve, the assets, and at the same time they had gone off to court to apply for a Mariva injunction, and the question was, should I decide this, or should I wait for the court to come to a conclusion? I took the view that I didn't want to trespass into the court territory, because it would be very much the similar considerations that would apply. So I told, and then because it was an injunction, it wouldn't have been so, the period wouldn't have been so extended. So what the parties did was that they agreed to basically hold the application before me in abeyance, and they did resolve the issue in court. And then after that, mine became academic. So we pushed on with the arbitration. So I think it depends very much on the circumstances, because sometimes, you can decide to push on because it would waste a lot of time if you don't. But other times, you feel very awkward transgressing into what appears to be something that's sized of the court. I'm not sure what thoughts you have on this, Francis, if you, on this kind of situation.
Francis?
Well, I agree with what Raj basically said. Sometimes you're in a difficult position, and ultimately, I suppose in this situation, you do what is common sense, lah. So similar to what Raj had, I had a case where there was a sale of an automotive business, international business, from some Indian parties to some European parties, right? And so they commenced arbitration, but this business was so complex. They had multiple agreements between them. So it wasn't a third-party situation. It was the same parties. So what had happened was they were, represented in respect of different agreements by different lawyers internationally. So there was several suits running in London. And then, for some of the agreements, they started an arbitration, right? And I realized that I couldn't really decide the issues before me, which involved, maybe ordering one party to transfer his shares to the other party without doing a valuation exercise. But that valuation of the shares of this huge company the parties had chosen to put it before a judge in London. So I basically told them, look, you could have actually put it before me, but you chose to put it before a court in London. And of course, it's an SIAC arbitration and I'm under pressure to come up with an award quickly, right? And so in the end, I had no choice. I determined all of the other issues. There were complex issues relating to guarantees, and construction of guarantees. But then it came to a point where I couldn't move unless I had the valuation of the shares determined. And because the parties had chosen not to put it before me, I couldn't decide finally. So, in these situations, it's just a matter of what is commonsensical. So I then told the SIAC I'll issue this award, but it was floating. And then when the decision comes out, it'll come back to me and it's just come back to me. So I guess it's all commonsensical. Back to you, Julian.
Thank you, Francis. Commonsensical approach is something that we can attach to quite easily.
In short supply sometimes.
Let me come back to you, Raj. The sticky issue of discovery.
Yeah.
Has discovery applications in the arbitrations you've come across morphed into US type discovery applications? How would you, first of all, sitting as arbitrator, how would you deal with a discovery application? How would you view it?
Okay, I can tell you that my own feeling is I think some of these things are, they kind of fly in the face of what arbitration should be. It becomes a parody of court, and worse still, a parody of the US court, where you have discovery application upon discovery application and cast very widely. My own feeling is that I tend to treat them very strictly, and I only allow those things which are clearly relevant to the outcome. Otherwise, it's a very thin line between what's relevant and what's just a fishing expedition to go off and look for something that might just help in their case. So I take that a position. Unfortunately, some of the arbitrators that I appear before, where I am counsel, tend to take the other approach because they seem to think they don't know enough about the case, so it's safer to allow the application. But they don't realize how much trouble it puts the parties and counsel in by having considerable quantities of documents produced, none of which, or very small amounts of which, might ultimately be of any relevance to the arbitration. So that's been my approach. I'm not sure what the others feel about it.
Thank you for that, Raj. I will come back to you on the red fund schedule for the benefit of the younger members in our audience. Perhaps I'll get you to give your views on how helpful the red fund schedule is. But before that, can I turn to Sanjay? Kick the can down the road or deal with the relevance of the documents, or how would you approach it?
I mean, personally, I find that in most cases, if you have hundreds of bundles and you're only looking at 5% or 10% of the documents, a lot of it is just put in there for no apparent good reason. So ideally, if you can persuade the parties to just put in what is relevant and get on with the case, that's so much better. But unfortunately, that's not always the situation. And I will, in my personal view, I try to keep the discovery to a minimal. Try to avoid having to lug bundles and fill up my office with unnecessary bundles of documents. But to be fair, Foo, I'm guilty of mass producing documents as well. I mean, so I think Harbans is listening to this.
Francis, as arbitrator, how would you view a discovery application? Do you deal with it there and then on the available facts, or would you take the safer route of dealing with it, letting the documents in if there's some doubt and dealing with it at the end?
Well, Joon Liang, I think, I'm actually finalizing, I'm sitting in a 3-man panel of arbitration based in Malaysia, and there's a lengthy request from claimants and respondents, and I need to issue the order today. But actually Raj and Sanjay have covered the ground. So basically there are two considerations, right? Fairness and justice. So if the documents are really relevant, it will help one party, then obviously you allow it. But the next big consideration is efficiency. You can't have the matter bogged down for 6 to 8 months, the way it happens, as Raj has pointed out, in court over discovery. We can't afford that, right? Because, as Sanjay has pointed out, in reality, only a small fraction of these documents will move the tribunal, right? So you have to strike a balance. So if it's relevant, but the scope is so broad, then you whittle it down, either in terms of time frame or in terms of the categories of documents. So you make it really, you balance both fairness as well as efficiency in a way that, promotes speed and efficacious administration of the arbitration. It's a balance, but that's why arbitrators are there, right? Back to you.
Yes, thanks. So I'll come back to you, Raj. Reference schedule. Could you perhaps give a brief overview of how useful that is to the arbitrator in the context of a discovery application?
Okay, it is extremely useful to an arbitrator because the schedule is basically, and for the benefit of those members who may not be familiar with it, the schedule is basically, say, for example, one party's request for a document or class of documents, which will be in one column. Then the next column will be their reasons for making that application. And the third column will be the other party's response to that, and maybe a reply by one party. So they're all arranged in columns and relating to each category of documents or documents, specified documents. And there's one column for the arbitrator to make its decision. I found that these kinds of schedules, the reference schedules, and in a different context, the Scott schedules for defects and all that, where you got a large number of items to deal with, rather than to have them come in separate applications. Then you go to read through, an application, you got to sift through something else. Here, it forces the parties to summarize and maybe cross-reference it back to where they made the actual application. It's all in one place. You get the gist of the application. You can form a preliminary view. If you're not sure, or if you want to be thorough, you can go and look in detail at what the parties have submitted, and then you can make your decision. So it's of great help to the arbitrator. And I tend to usually try to sell this to the council, and not just as I said, in the context of reference schedules, but more in terms of Scott schedules. Say that, look, it's going to make it easier for me to look at everything you want me to look at, because it's all in one place. And they generally pull along and take the trouble to compile it for me. And I think in the end, it leads to a more reliable and fairer outcome.
Thank you, Raj. With time running short, I'll press on to that with the next area. We are going to look at interim measures. As most of you in the audience would know, interim measures typically under most national arbitration regimes, you can either take it in court or you can take it in the arbitration itself. So it's an interplay between the two. There are obviously practical considerations. I will turn to Francis on this. Would you say that the court is the port of first call, or are there any circumstances in which you feel that an arbitrator would be the better option?
I think the audience here would be very familiar with this. If you had an arbitration and you went to court to seek interim measures, guess what the court will do? The court will say, why aren't you seeking this from the tribunal? So generally speaking, the entire reason you're in arbitration is because the parties chose party autonomy, they chose the arbitrator route as opposed to the court route, right? So there are only very limited situations when the court will entertain you, right? So let's say you're having a BICAM rules arbitration and you went to court to seek injunctive relief. And you told the court it's very urgent, right? So the court will ask you, even if it's very urgent and your tribunal has, well, if your tribunal has been appointed, then you have no chance. The court will throw you out. But let's say you say the tribunal has not been appointed and this is urgent, the court will still ask you, why can't you go before an emergency arbitrator, right? Because the Schedule 2 BICAM rules, like the SIC and other rules, allows for emergency arbitrator relief. In fact, I'm due to release emergency arbitrator award today, and so the court will say, why haven't you gone before the emergency arbitrator, right? If you're in a BICAM rules situation. Now, so in order to persuade the court, you need to give the court a good reason why the court has to intervene. And there are several reasons, right, in the past. And all of the panelists would be very, very familiar, and you need to bear this in mind. Number one, if you are seeking relief against a third party, not a contracting party, right? So let's say there are two contracting parties, buyer and seller of coal or whatever, but you want to injunct the bank account of the respondent, right? And so you want to injunct the bank, right? So then you need, an emergency arbitrator award is not going to be helpful because the emergency arbitrator can only injunct the party to the arbitration agreement, not a third party. So then the court will intervene, number one. Number two, if you say the matter is so urgent that even an emergency arbitrator won't have time to deal with this. When you go to court, you can go to a duty judge. Sometimes you can even get an audience before a judge on a Saturday. And the judge will, in a matter of 2 hours, pass the order, right? Whereas in an emergency arbitrator situation, the BICAM rules the timelines are similar to SIAC. You make the application, within 2 days, BICAM will appoint an emergency arbitrator. The emergency arbitrator has to call for a CMC within 2 days and issue a ruling within 14 days of appointment. That may be too late, right? If you have somebody moving the cargo now, you need an injunction today. Then you can go to court and say, even the emergency arbitrator route, it's not fast enough for you, right? One other very rare situation, for instance, in Switzerland, let's say you need to enforce an award that an injunction that you can get from this BICAM arbitration. You need to enforce it in Switzerland, let's say. Let's just take Switzerland. Under the Swiss rules, they don't really recognize emergency arbitrator or arbitrator ordered injunctions because under Swiss rules, peculiar Swiss rules, they are not considered awards, or they are not given the due amount of recognition that they should otherwise have. So you have no choice. You have to go to court so that the court will grant you an injunction, and you can take that court order to Switzerland and have it efficaciously enforced. If for some reason you can't go to Switzerland directly, right? So only in those rare situations, you don't go to court. I mean, you go to court. Otherwise, you seek refuge within the rules. Back to you, Julian.
Thanks, Francis. Turning to you, Sanjay. Any thoughts? Court first, arbitrator first?
Well, I think court first, because for the reasons that Francis alluded to, but also, you file an injunction in court, you can appear before a judge within a couple of days. And sometimes to ensure the injunction is not rendered ineffective, you serve the papers, you threaten contempt, you can do many things. This is unfortunately not available if you appear before an arbitrator or emergency arbitrator. So to me, if the relief which you seek is urgent, like a Mareva or some sort of interim injunction, I would go to court first. And I think that would be the more efficient way of doing things.
Sanjay, can I just add one thing? That's a very interesting thought, because even, let's say you find that you want a Mareva or Anton Pillar order straight away, right? You can go to court and say, I've already applied for emergency relief, but in the time that it takes before the emergency arbitrator rules on it, you give me a bridging injunction. So that's possible. Back to you. Sorry, Sanjay.
No. So I think to answer your question, Foo, I think I would go to court first for the reasons you set out. I also think that even if an arbitrator's award issues an award, the value of that award before it's enforced can you cite the party for contempt if they ignore that award? I mean, I personally, I haven't seen an authority which suggests that to be the case.
So the process that you might take to have that emergency award enforced in court, or take the effect of a court order, it's the same time you will take to go to court to get the same order firsthand.
Oh, it's possible to go to court.
Yeah.
Yeah.
Can I turn to you, Raj, for your thoughts on this area? Which
my thoughts are generally in alignment with Sanjay, but I think maybe the question that I have in my mind is that when we're looking at it from a context of an arbitration between domestic parties and a domestic court, then that makes perfect sense. The thing is you go to court and avoid jumping through additional hoops. But I think the considerations might be somewhat different. If the parties or if the injunction is supposed to injunct something in another country, as Francis mentioned just now, and obviously it depends on the country concerned, whether you can actually approach the courts in that country and get the relief that you want, or whether or not you need to get an emergency arbitrator award and approach the courts in that country with that award. It really depends, but I think the considerations might differ if you're talking about a cross-border situation.
Certainly. Thank you, Raj.
Sorry, Foo, before you go on to the next topic, I just want to put this out there. In our Malaysian Act, you've got Section 11, which talks about the powers of the court to grant interim relief. After the amendment to the Act, I just wonder whether the courts have the power to grant a Mareva injunction. If you look at 11(1)(c), it's the language is that it is in relation only to the admiralty jurisdiction of the High Court. So in relation to commercial matters, how does it sit? I mean, I argued this in the High Court. I lost, but the decision has also been picked up by I think the Singapore Law Review or something like that. And so I think if you look at the language of the Act, one needs to consider it carefully whether you can actually go to court for Mareva injunction. You're just putting it out there.
Thanks, Sanjay. I'll move on to the penultimate question of the day, if not the final question. We've spent some time this afternoon looking at interlocutory applications. Now, put yourself in a position, and I'm going to turn to Francis on this. Put yourself in a situation where you are the arbitrator and you face one interlocutory application after another. How would you deal with it, Francis?
Again, it comes back to the point that Raj made, which is that parties forget they're in arbitration, and maybe they need to, justify the level of work in their billing. So, they take out a lot of applications. And usually in a rapid fire sequence, sometimes it appears, it may be a misapprehension, but it appears as if it is meant to flabbergast the opponent, right? And the timing is always on a Friday evening or, just before your opponent goes on leave. I don't know how they discovered all these nuances. So I think as an arbitrator, look, again, you're concerned with the two things, right? Justice, doing what is right, and doing it within a reasonably quick or expeditious time frame. So, and as an arbitrator, because you are also acting as counsel in many other matters, and you also pull up some of these strategies to befuddle your opponents. You can, as an arbitrator, you're in a position to assess, what are the key interlocks and what are perhaps less important. So, I think it's just a question of being firm, giving parties, once an application is taken out, giving parties very limited timelines to respond, and deciding it sometimes just on paper, because it is important that you as arbitrator don't get bogged down. Sometimes you have arbitrators who are very, very concerned about due process. And I think my sense is that they do get bogged down. One party will say, I'm having this public holidays, it's now Ramadan and I need, an additional 4 weeks. And then 4 weeks later, when he replies, I need another 6 weeks because, I'm then on leave. But, you can't have it all, so you need to impose time limits, you need to impose page limits, you need to, get the case to move. So I think it requires arbitrators with the cooperation of counsel to be firm-handed, but even-handed, right? Give them a chance without letting them run procedural rings around you and delay the matter unnecessarily. Thank you.
Thank you. Sanjay, I'll turn to you. Francis mentioned being firm, and there's, of course, the due process paranoia. Seems to be more prevalent amongst arbitrators than judges. How would you balance it if you were the arbitrator?
Actually, to be honest, I take quite a firm hand now. So I just try to push it forward as hard as I can. I know I don't worry too much about all this due process. So long as I've given everybody ample opportunity to put forward what they need to put forward, just move on with it. Because what is really annoying, and the people try to delay the matter, and it's not necessarily the respondent only. Sometimes the claimant is not prepared. They put in documents in the last minute. They suddenly have an additional witness. They suddenly discovered also the rubbish. It's very annoying because time is fixed and time is money. So I think it's important that everybody plays their role and move it forward properly.
That's encouraging. Raj, I turn over to you.
Yeah, I think it very much depends on the facts, but I also take the view that you, as counsel, you can sniff out when people are not making genuine applications, and I think once you're firm with them, when they, when you know what they're up to, and they know that you know what they're up to, I think then they fall into line, but I think you need to establish the battle lines early, and most of the time I decide these things on paper. I'm not going to try to get free dates from everyone and fix all the hearings and all that. So I think that so long as each party has the same reasonable opportunity to put in their submissions, that's good enough for the requirements of due process or natural justice.
Thank you, Raj. We've got just under 5 minutes to go before the end of our session. So let's open it to the floor for Q&A. Sharifah, I may be wrong, but I don't see any questions in the chat, in the chat function. If there aren't any questions in the chat function, could I invite perhaps questions from the floor if anybody has any questions?
Yeah, not very shy.
I suspect nobody's there, Foo.
Yeah, Friday.
There are 34 participants.
It's almost 5 o'clock.
No questions in the chat group, right, Sharifah?
I actually have a question.
Oh.
It's actually quite common for following what Mr. Francis said earlier, that arbitrators and counsels have to be firm when it comes to trying to find ways around the procedural process, right? So how can you share some of the stories of how you yourself handle when you know that either the arbitrator or the opposing counsel is purposely delaying the process? How do you handle it?
Now, Sharifah, if the arbitrator is purposely delaying arbitration, you're in trouble, right? He's the boss. He dictates, he manages it, right? But, there are many strategies. I don't think so. I think arbitrators want to get reappointed. So they want to be in the good books of the arbitral institutions, which the bulk of our arbitrations today are not ad hoc, they are arbitral institutions. So arbitrators, I think, try to do their best. Now, but you have this problem where arbitrators, like Sanjay, Raj, or Joon Liang are very busy. So counsel are aware that if they flummox their opponents and the panel with multiple applications, given that these arbitrators are busy and the opposing counsel is also busy, they're likely to get flabbergasted, and then when they ask for extension, they're likely to get it. So I think it behoves the arbitration community to step up, right? Firstly, counsel should not be making these sort of applications. But if they do, then the arbitrators need to step up and find ways amidst a busy schedule to deal with it expeditiously. So many strategies. So certain rules allow for the presiding arbitrator to take the lead on interlocutories. That's not often used, but I've used it a couple of times. When, we will say that the lead arbitrator the presiding arbitrator will rule, and if the parties also want the orders to be modified or reviewed by the others, then they have a time to do that. That also speeds up things. Alternatively, what I will do in matters where I'm presiding, if there's a flurry of 5 or 6 interlocutory applications, I will divide it, right? So one of us will take 2 each, will propose orders with reasons, and it makes it easier. Like Rajendra mentioned, right? When you have things clearly laid out in a Scots or reference schedule, setting out what is the issue, what is the prayer, what is the claimant saying, what is the respondent saying, what is that arbitrator who's taken charge says, this is what he recommends. It's very quick, very fast for you to come to a decision, right? Based on what you know of the case. So there are all these strategies. And the thing is this, I think it behoves you, if you take on an appointment, you need to have enough bandwidth to deal with things quickly, even if you have difficult counsel on one side, piling interlocks after interlocks. But, I'm sure Raj or Sanjay or Joon Liang may have a different perspective. Over to you.
Well, I suppose if all else fails, just think about how a judge will deal with it in court. Then you have the other extreme of it. And I suppose you moderate something in between.
I would say this from the Malaysian context. I think a lot of it is our approach to arbitration is not as sophisticated as it can be, and it's not just the fault of arbitrators. It's also the fault of the lawyers and also the parties, because they don't take it and move it forward. And the other thing is that if we have dates fixed for arbitration, it's not unknown where the courts will say, well, I'm to be given priority, and please go to the arbitrator that you need to move these dates. So we have these problems as well, and I think the entire arbitral community or the legal community needs to look at it a bit more carefully, and so that we can promote arbitration properly.
There's a question from the floor. Perhaps, Raj, I'll ask you to start it off. The question is this: essentially, when you are faced with a relatively young and inexperienced arbitrator, you make an or there are attempts, I suppose, to delay proceedings, or you make a genuine application and you want it dealt with expeditiously. How would you address or guide the arbitrator? Would you like to start it off, Raj?
Yeah, because I think we are in this sense we have the converse situation, because we are talking about converse to what maybe Sanjay was saying. Because from what I understood, Sanjay was saying that that a number of people in the arbitral community are not really familiar with the process, and I suppose that's a matter of education before they get there. But I think we have a different problem when you have an arbitrator who is not so well versed, and I think their counsel have to take the lead to gently guide the arbitrator, because I think I start off with the premise that everybody wants to get it right. The arbitrator, he may be young, he may be inexperienced, but he would still want to get it right, and he would be very grateful for any guidance he can get from counsel. So here is where I think counsel have to live up to the standards of ethics, and not to take advantage of the situation to mislead the arbitrator or to lead him down the wrong path, but to do their best to help the arbitrator to get to the right decision. It might seem idealistic, but I think that's what we have to aim for. And in my experience, many counsel will do that, because we are there to do our job, and we're there to make sure that the arbitrator gets the decision, whether it's for or against our client, but generally gets it as right as possible in the circumstances. So that's what I would say, counsel to assist in as best they can.
There's another question that has come in. I'll pose that to Sanjay. So the question is this: how would a panel deal with a preliminary point that is put forth by one party and the party claims that it is able to narrow the issues, but the other party disagrees? How would you, as the arbitrator, deal with this preliminary point? So there's a dispute as to whether it will save time.
you'd go back to the pleadings, right? And what's the reference? What are the issues you asked to look at? And if you can, that point can address most of the issues, then you deal with it. If you can't, then you can't.
Yes. I suppose then after looking at the pleadings, what you want to do is, assuming that point is decided one way or the other, how much time does it save? Or what issues are resolved?
Yeah, so if that point can resolve the substantial part of the dispute or the issues, then you allow it to go through. But if it can't, then you'll have to hear the entire matter. But I think, to be honest, you see, we don't have the powers of court like where you got a point of law, can't necessarily narrow it so easily. There'll be allegations of breach of natural justice and so on and so forth. So you have to be a bit mindful.
All right. We are 5 minutes past. Any other questions from the floor? Otherwise, I will call this to an end.
Could I add, this is just another housekeeping matter, but we're proud to announce that our recordings of the BicTok will be uploaded on the website. So stay tuned for when we have successfully uploaded the talks. Thank you. Thank you for attending, everybody.
Thank you, Sharifah. That leads me to thank our speakers, Raj, Francis, Sanjay. Thank you so much for taking time off, and they spent quite a bit of time preparing for this. So a round of applause wherever you are to them. Thank you so much.
And thanks, Joon Liang and Sharifah. Joon Liang, you obviously did a lot of background work for us, so thank you for that.
Not at all. Thanks, everyone.
Bye.
Again.
Bye.